Warm welcome from the delegation of the Netherlands. In our presentation, we will discuss the following points: general information, trusts in the Netherlands proper, trusts in the Kingdom of the Netherlands, comparison between Netherlands, France, and England. The Kingdom of the Netherlands constitutes of Aruba, Saint Martin, Curaçao, and the Netherlands proper. As we represent the kingdom as a whole, we will discuss legal systems in the Dutch Caribbean as well. Originally, the Dutch Civil Code does not recognize the legal concept of trust at all. However, in legal transactions with common law countries, the Netherlands found itself confronted with trusts. The application of trusts for the common law countries happens regularly in both family law as well as for commercial practices. Hence, it was profitable for the Netherlands to create a clarity through a trust treaty made in 1985. At the time, the Minister of Justice argued that the creation of the treaty was a portrayal of the Dutch acceptance of the common law concept of trust. At the same time, he made it very clear that he did not deem it necessary for the Netherlands to create a system of national trusts. This idea was supported by the advisory body of the States General. Additionally, there was great pressure to sign the treaty coming both from the financial and commercial sectors, as it would be more efficient for their trade relations. The definition used for trust in the Netherlands is prescribed in the Article 2 of the Hague Convention on Trust. The Dutch lawmaker introduced the conflict law of trusts, which was later transposed into Book 10, Title 11 of the Dutch Civil Code. In principle, it does not state anything different than the already signed convention of the law applicable to trusts and on their recognition. Despite the fact that the Netherlands signed and ratified the Hague Convention on the law applicable to trusts, it has not recognized the Dutch law system. The idea that trusts could not easily be united with civil law seems to be the main reason for refusal. Moreover, the lawmaker points out that the Dutch Civil Code already provides for multiple different ways to create the same result as trust. A significant difference in the Civil Code of Curaçao is found with regard to trust. As it was mentioned before, it is not legally possible to create a trust in the Netherlands proper. Curaçao introduced trust in the new Civil Code on the 1st of January 2012. This trust is initially based on the common law express trust, but stripped of its equitable character in order to fit into the legal system of Curaçao. Due to Article 40 of the Charter of the Kingdom of the Netherlands, the decision to adopt the trust in Curaçao has consequences in the Netherlands. Article 40 states that authentic acts may be enforced throughout the kingdom, with the result that even Article 13 of the Hague Trust Convention does not apply to trust from Curaçao. This means that even though it is not possible to set up a trust in the Netherlands under Dutch law, a trust set up in Curaçao has legal force in the Netherlands. The position of the Netherlands with regards to the trust is growing more exceptional as civil law countries like Germany and France have adopted trust-like devices. However, despite those changes, the Netherlands is not eager to change their position towards the trust. The position of the Netherlands towards the trust is completely different from the English approach. Where trust has been a part of legal English system for centuries, it is alien to the Dutch one. The main reason why the two systems differ has to do with the concept of dual ownership and separate patrimony. English law makes a distinction between legal and equitable ownership. This is an important characteristic of a trust to protect the beneficiary in case of the insolvency of the trustee. In the Netherlands, ownership cannot be divided and a separate patrimony does not exist. Hence, property held in trust by a trustee is not safe from the trustee's creditors as it is in England. In case of insolvency of the trustee, the person for whom the assets are held is not protected from the insolvent manager's creditors. In 2007, the French lawmaker introduced a trust-like device fiducie. Article 2011 of the French Civil Code defines fiducie as a transaction through which constituents transfer rights to fiduciary could, keeping them separate from their patrimony, act for the benefit of the beneficiary. Unlike in the Netherlands, the introduction of fiducie in France allowed for assets to be separated from the patrimony of the constituent, what has put an end to the fundamental concept that the person's patrimony cannot be divided up. However, the French device is subject to many limitations. It renders its application more restricted than the English trust. Fiducie needs to be expressly created, which prevents the courts from creating constructive trust. Furthermore, only specific institutions or professions like financial institutions or avocat can function as fiduciary. Imposing limitations in approaching trust-like devices with suspicion renders the French approach more similar to the Dutch. Thank you for your attention.